The elections, whether annual or triennial, being shown by the 22nd, that which comes in the next place to be considered is the 23rd order, showing the power, function, and manner of proceeding of the prerogative tribe. The power or function of the prerogative is of two parts: the one of result, in which it is the legislative power; the other of judicature, in which regard it is the highest court and the last appeal in this commonwealth. For the former part, the people by this constitution being not obliged by any law that is not of their own making or confirmation, by the result of the prerogative, their equal representative, it shall not be lawful for the Senate to require obedience from the people, nor for the people to give due obedience unto the Senate, in or by any law that hath not been promulgated or printed and published for the space of 6 weeks, and afterwards proposed by the authority of the Senate unto the prerogative tribe, and resolved by the major vote of the same in the affirmative. Nor shall the Senate have any power to levy war, men, or money, otherwise than by the consent of the people so given, or by the law so enacted, except in cases of exigence, in which it is agreed that the power both of the Senate and the people shall be in the dictator, so qualified, and for such a term of time as is according unto that constitution already prescribed. While a law is in promulgation, the censors shall animadvert upon the Senate, and the tribunes upon the people, that there be no laying of heads together, conventicles, or canvassing to carry on or oppose anything, but that all may be done in a free and open way. For the latter part of the power of the prerogative, or that whereby they are the supreme judicatory of this nation, and of the provinces of the same, the cognizance of crimes against the majesty of the people, as high treason, as also of peculation, that is robbery of the treasury, or defraudation of the commonwealth, appertaineth unto this tribe. And if any person or persons, provincials or citizens, shall appeal unto the people, it belongeth unto the prerogative to judge and determine the case, provided that if the appeal be from any court of justice in this nation or the provinces, the appellant shall first deposit £100 in the court from which he appealeth, to be forfeited unto the same if he be cast in his suit by the people. But the power of the council of war, being the expedition of this commonwealth, and the martial law of the strategist in the field, are those only from which there shall lie no appeal unto the people. The proceeding of the prerogative in case of a proposition is to be thus ordered: the magistrates proposing by authority of the Senate shall rehearse the whole matter and expound it unto the people, which done, they shall put the whole together unto the suffrage of those boxes, the negative and the affirmative and the non-sincere, and the suffrage being returned unto the tribunes, and numbered in the presence of the proposers. If the major vote be in the non-sincere, the proposers shall desist, and the Senate shall resume the debate. If the major vote be in the negative, the proposers shall desist, and the Senate too. But if the major vote be in the affirmative, then the tribe is clear, and the proposers shall begin and put the whole matter with the negative and the affirmative, leaving out the non-sincere by clauses, and the suffrages being taken and numbered by the tribunes in the presence of the proposers, shall be written and reported by the tribunes unto the Senate. And that which is proposed by the authority of the Senate and confirmed by the command of the people is the law of Oceana. The proceeding of the prerogative in case of judicature is to be thus ordered. The tribunes being auditors of all causes appertaining unto the cognizance of the people shall have notice of the suit or trial, whether of appeal or otherwise, that is to be commenced, and if any one of them shall accept of the same, it appertaineth unto him to introduce it, a cause being introduced, and the people mustered or assembled for the decision of the same. The tribunes are presidents of the court, having power to keep it under orders, and shall be seated upon a scaffold erected in the middle of the tribe. Upon the right hand shall stand a seat or a large pulpit, assigned unto the plaintiff or the accuser, and upon the left another for the defendant, each, if they please, with his counsel. And the tribunes being attended upon such occasions with so many ballatines, secretaries, doorkeepers, and messengers of the Senate, as shall be requisite, one of them shall turn up a glass of the nature of an hourglass, but such an one as is to be of an hour and a half's running, which being turned up, the party or counsel on the right hand may begin to speak to the people. If there be papers to be read, or witnesses to be examined, the officer shall lay the glass sideways until the papers be read and the witnesses examined, and then turn it up again, and so long as the glass in running, the party on the right hand hath liberty to speak, and no longer. The party on the right hand having had his time, and the like shall be done in every respect for the party on the left. And the cause being thus heard, the tribunes shall put the question unto the tribe with a white, a black, and a red box, or non-sincere, whether guilty or not guilty. And if the suffrage being taken, the major vote be in the non-sincere, the cause shall be reheard upon the next juridical day following, and put unto the question in the same manner. If the major vote come the second time in the non-sincere, the cause shall be heard upon again upon the third day. But at the third hearing, the question shall be put without the non-sincere. Upon the first of the 3 days in which the major vote comes in the white box, the party accused is absolved, and upon the first of them in which it comes in the black box, the party accused is condemned. The party accused being condemned, the tribunes, if the case be criminal, shall put with the white and the black box the questions of such of them as regard had unto the case. They shall conceive most proper. 1. Whether he shall have a writ of ease. 2. Whether he shall be fined so much or so much. 3. Whether he shall be confiscated. 4. Whether he shall be rendered incapable of magistracy. 5. Whether he shall be banished. 6. Whether he shall be put to death. These, or any 3 of these questions, whether simple or such as shall be thought fitly mixed, being put by the tribunes, that which hath most above half the votes in the black box is the sentence of the people, which the troop of the third classis is to see executed accordingly. But whereas by the constitution of this commonwealth it may appear that neither the propositions of the Senate nor the judicature of the people shall be so frequent as to hold the prerogative in continual employment, the Senate, a main part of whose office it is to teach and instruct the people, shall duly, if they have no greater affairs to divert them, cause an oration to be made unto the prerogative by some knight or magistrate of the Senate, to be chosen out of the ablest men, and from time to time appointed by the orator of the House, in the great hall of the Pantheon, while the Parliament resideth in the town, or in some grove or sweet place in the field, while the Parliament for the heat of the year shall reside in the country upon every Tuesday morning or afternoon. The orator appointed pro tempore unto the office shall first repeat the orders of the Commonwealth with all possible brevity, and then, making choice of one or some part of it, discourse thereof unto the people. An oration or discourse of this nature being afterward perused by the Council of State, may, as they see cause, be printed and published.